Hey everyone, I hope you're doing well and staying safe during this time. If you're new here, welcome to the channel. Like I said, thank you so much for checking me out. If you haven't done so, please make sure to hit that subscribe button just right below the video. Cool, thank you so much. I really do appreciate it. And if you're returning, welcome back. Thanks again for your support. I truly do appreciate having you here.
Today is the day, guys, February the 17th. Now, we're all waiting. I mean, I'm recording this video early in the morning, so we have not heard any outcomes yet. However, there are a couple of lawyers in the XRP community that are giving their 2 cents. One of them, of course, Jeremy Hogan. He's predicting the outcome of the SEC versus Ripple lawsuit. This brought to us by Ant1 on Twitter. So we know about the unsealing of the documents, and they will be unsealed following Judge Annalisa Torres's ruling last week, which we've talked about, which ascertain whether Ripple sold unregistered securities. As we know, many analysts believe that the documents would certainly put an end to the SEC lawsuit. So this is D-Day. Essentially, we are going to get information that could have a huge influence on the decision of where the path or where this lawsuit is going next. So Jeremy Hogan did a live YouTube interview the other day hosted by Scott Powell, the COO of Wells Fargo, commenting on how the lawsuit has gone so far and the possible outcome. Attorney Hogan noted that despite several pieces of evidence that could have been provided in the case, he has seen only a few so far. So this is this idea that the entire puzzle hasn't been put together yet. I like the puzzle analogy that Jeremy uses because it really does give us a good idea. You know, even when you have most of the puzzle put together, you can kind of make out the picture, but in some cases, there still needs to be a few more pieces put into place in order to get the full picture, and that's where we're at right now. There are 100 pieces of evidence out there, and we've only seen about 5 or 10. So right now, we haven't seen so many. But with this unsealing of the documents today, on February 17th, we are going to get many more pieces of this puzzle. So far, the litigation has gone very well from Ripple's perspective, but I've only seen 5 pieces of real hard evidence. So is this a win or lose? In the meantime, vital documents will be unsealed today that could bring the lawsuit closer to an end. So that is the assumption, right? What we get today really will change that path of the lawsuit, and it's the final verdict, essentially. I mean, not officially, but we will get more of an idea of where this is going once we see what is in those documents. Once the documents are officially unsealed, it is expected that several legal experts, including Hogan, will be able to give a better analysis of the possible outcome. While some investors expect the outcome could end in a win or lose, several others, like Attorney Hogan, predict that the lawsuit will end in a settlement. So that is kind of the anticlimactic, I suppose, part of this. We'll get the evidence, and, you know, everybody wants their, you know, we always feel, we see movies, and there's always a victory at the end. Well, lawsuits, you know, they don't usually end up that way. Usually there is a settlement where both sides negotiate, and they come up to an agreement where both sides are not necessarily 100% happy, but can live with the outcome. So here's a quote: "The most probable resolution is a settlement, and that hasn't changed since the beginning," says Jeremy Hogan. However, should the lawsuit not end in a settlement, which is also a possibility, Ripple's XRP future will be determined by whether the case will end in a win. A win for Ripple would promote the widespread adoption of XRP and the possible relisting of the cryptocurrency on various US-based platforms. Furthermore, Ripple could conclude plans to take the blockchain company public. In addition, a win would aid in the classification of crypto assets in the near future. A loss for Ripple would continue to see XRP delisted on all US-based exchanges. However, XRP trading will still continue in offshore exchanges where the SEC has no control over it. So that is kind of the worst case scenario, I guess. The worst case scenario is basically we are trading in the same atmosphere, the same crypto atmosphere as we're trading today. Basically, no regulatory clarity in the U.S., the delistings on crypto exchanges, and would likely be the case that U.S. customers would have to purchase XRP on foreign exchanges if they wanted to take the risk. But that would be the absolute ultimate worst case scenario. I do not think we are going. I think Ripple would settle before that happened. I also saw this from Michael at Val5 Links. Now here's another perspective from Cointelegraph. Again, all eyes on today, February the 17th. This article just goes through some details about the case, the history, of course, that we all know about, and the 2012 legal memos. One of the pillars of Ripple's defense is that it simply did not know that its XRP token could be categorized as a security. The SEC, the argument goes, should have notified the company, so we all know about that. This powerful argument could go bust, though, if it turns out that Ripple knew it was possible the SEC would take issue with the status of the token, which they are saying they did not have fair notice of that. Peter Vogel of counsel and a member of the blockchain task force of law firm Foley and Lardner explains to Cointelegraph. Now, he's also chiming in on this. U.S. District Judge Annalisa Torres ruled that by February 17th, Ripple would have to make public sealed legal memos from 2012 from Ripple's lawyers advising Ripple before launching XRP. The SEC claims that Ripple was advised in 2012 that XRP would be deemed a security under federal law, so Ripple was well aware of the risk that the SEC would bring a lawsuit. Ripple claims that the 2012 legal memos related only to proprietary internal strategies. So that is what Vogel is stating here, that Ripple did not actually believe that there was any clarification on the XRP cryptocurrency, and that's why they are claiming they did not get fair notice. Yet they are saying, the SEC is claiming that no, we did give fair notice, but Ripple's saying that those 2012 legal memos related only to proprietary internal strategies. So if the memo clearly points to the absence of a federal law violation, Ripple's argument will receive a massive boost. However, evidence suggesting that the firm's executives chose to ignore their lawyers' relevant concerns ahead of launching XRP could considerably deflate Ripple's fair notice argument. So this is the situation we're in, guys. I know there's so much more with regards to the evidence in the case, and of course the Ethereum part of this is not even related to the Ripple XRP case specifically. However, many are questioning their legitimacy in relation to the SEC and the relationship that they have. And finally, another lawyer here, Amina Hassan, litigation partner with law firm Hughes and Hubbard and Reed, thinks that the fight over the scope of the commission's deliberative privilege is even more interesting than what's inside the 2012 memos. Hassan commented, if the court's decision stands, it could have a far-reaching impact. And so Judge Annalisa Torres probably, if she's smart, which I have a feeling she is very, very smart, considering the position she holds, is going to realize that this is going to have far-reaching implications to the rest of the cryptocurrency space in the United States. And so she's got to put some very, very careful effort in making this final decision. This quote goes on by saying, opening similar types of SEC and other agency documents to discovery. While any discovery disputes around agency notes will necessarily be fact-specific and resolved on a case-by-case basis, the decision does provide litigants a helpful hook to seek similar documents from the government. So how does this end? And, they are saying as well, the fact that Ripple chose to engage in court rather than going for a settlement right away does not rule out the possibility of a settlement. So they are saying, a settlement still very, very likely. Since about 95% of all lawsuits settle before trial, it seems likely that we will never have a jury trial, but the interpretation of these 2012 legal memos may be a factor in some settlement of the current SEC lawsuit. I personally also think that they are going to settle. There's never a clear cut, or at least it seems like there's never a clear cut verdict on this. Maybe Ripple was in the wrong in some capacity, and maybe the SEC was in the wrong in some capacity, and vice versa. Ripple's likely in the right in some capacity, and the SEC probably has some sort of argument that can be justified in some capacity, which always tends to bring the two parties together and decide to settle. This is why 95% of cases do settle. So
I'm your guy. I will keep you posted. I'm your advocate. I'll be back on a daily basis, usually multiple times per day, with these videos to keep you updated with everything going on. So I hope you enjoyed the video. If you haven't done so, make sure to hit that subscribe button. Feel free to share any of my videos with your friends, family, social media, or anybody who may care to listen. Thanks so much for your continued support. I'm always here for you. I want to help you through this time. So thank you so much for continuing to choose me. Enjoy your day, stay safe, and I'll catch you again probably in a couple hours. Thanks, everybody. See you later.